Good afternoon, everyone. My name is Andy Pushlik. I'm the leader of the Toronto Labour and Employment Group, and I'll be your moderator today. Today marks our 14th webinar as part of our ongoing series of COVID-19 employment law webinars. As Canada's leading global law firms, we are able to rely on the expertise and experiences of our colleagues around the world. This gives us a unique advantage when discussing market trends and advising our clients on best practices. Drawing on that strength today, we are pleased to welcome our U.S. colleagues, Brian Baggett and Julie Vanneman, who will give their insight on what U.S. employers are doing as they manage their way through the ongoing COVID-19 pandemic. After Brian and Julie's presentation, my Canadian colleagues, Taylor Buckley and Stephanie Lewis, will answer some of the questions posed during the last week's webinar. During this webinar, you'll have the opportunity to send in your questions, which we'll try to get to either today or during next week's webinar. And of course, if you have any technical difficulties, please note that in the questions section, and we will ensure that one of our technical experts is able to respond. A few more housekeeping items. This webinar is being recorded, and access to the PowerPoints will be sent out by email early next week to everyone who RSVP'd for today. And we'd like to remind you about some of the resources that we have. If you Google Dentons, you'll be directed to our global COVID-19 hub. And that hub contains, quite frankly, hundreds of resources now from our Canadian colleagues and our global colleagues, and it's continuously updated. We have the Global Employment Law Tracker. We now have a Return to Work Tracker, and that gives advice or information on a number of employment-related issues in over 70 countries. In addition, last week, our U.S. colleagues released their Return to Work Toolkit. Now, this toolkit's a really good companion to the Canadian Return to Work Toolkit, which we released last month. Certainly, the U.S. Return to Work Toolkit is going to be focused on U.S. law and U.S. employers, but there's some really good practical tips that you may be able to adopt in your own workplace, regardless of where it's located. So with all of that in mind, I'm going to move on to introduce our first set of speakers. Brian is a partner in our Kansas City office, where he advises employers on all aspects of employment and labor law. He regularly represents employers in restrictive covenant disputes, discrimination and retaliation claims, and wage and hour class actions. Julie is a partner in our Pittsburgh office. She has significant experience assisting clients with workplace safety and health matters, including counseling on safety compliance programs, advising on responses to OSHA citations, and representing companies in OSHA investigations and other matters arising out of a workplace crisis. So Brian, Julie, welcome. Thank you so much for taking the time, and I think we'll get right into it. And Brian, why don't we start by, if you can maybe give us a lay of the land as to where things are at with the reopening status of the various U.S. states.
Sure. Thank you, Andy, and I hope everybody can hear me, and good morning to everybody. The reopening, as you may have seen in the U.S., is in full swing, as this map that you see shows. Most of the stay-at-home orders in all the states have been lifted or at least eased, with the exception of maybe California, Oregon, and New Hampshire. But even the stay-at-home orders there, certain restrictions have been eased. So the U.S. is quickly returning to work. It is still being done on a phased basis where businesses like entertainment businesses, movie theaters, obviously sports arenas and so forth, they are not fully reopened, but most traditional employers are. It's still a very localized process. There's been very little guidance from the federal government here as to when and how you can reopen. Most of it is directed by the state at the governor level, but even some states have left it to the discretion of local communities. And so it's important for any employer to know what the current restrictions are, certainly in their state, but even in their local community. As much as employers and states are reopening, as this map shows, there's another side to this story. While businesses are returning to work and employees are coming back to the workplace, what the latest maps show is that there has been a spike of cases in a lot of states that have reopened. Some maps show that the majority of the states in the Southwest and the South of the U.S. have seen a dramatic surge in cases and hospitalization. So this map only tells half the story with regard to what the situation looks like in these states regarding cases of COVID-19. The common theme for all these states is that even though businesses are reopening and employers are being asked, or employees are being asked to return to work, the common theme and requirement throughout all of this is that if an employee's position can be done remotely or through telework, then in nearly all cases, employers are, if not encouraged, required to have employees do that to tide the spread of COVID-19. That is going to likely be a permanent, or at least a semi-permanent fixture of the reopening. So this is the current status in the U.S. It remains to be seen whether this remains in place, if there is another surge as the fall arrives, but the U.S. employer base is returning to full swing slowly but surely. At this point, I'm going to hand it off to my partner, Julie, who's going to talk about the requirements by employers that their employees wear face masks and issues associated with that.
Greetings, everyone. I'm pleased to be speaking today. This is Julie Vanneman. Face masks are one component of an overall strategy. To explain why, where, and when they can be required, I have to give some background on occupational safety and health law in the U.S. The Occupational Safety and Health Act, or the OSHA Act, covers most private employers, and it sets out specific standards for certain workplaces or workplace activities. For example, there are standards for personal protective equipment, or PPE, and face masks with respirators are a type of PPE. Employers must follow specific standards established for those types of face masks. If they are necessary for a certain workplace activity, then yes, the employer can certainly require the worker to wear them. But that's really not what we're concerned about today. I'm not focusing on face masks with respirators that are required in high-risk settings like healthcare. Instead, I'm focusing on cloth face coverings used to try to prevent the spread of the coronavirus. So in addition to specific standards for specific activities, the Occupational Safety and Health Act also has what's called the General Duty Clause. Each employer generally has the duty to provide a safe and healthy workplace. Employers are responsible for identifying, quote, reasonably foreseeable, quote, hazards, and implementing workplace controls to mitigate those hazards. At this point, given what's happening, it's foreseeable that employees might transmit the novel coronavirus in the workplace, and cloth face coverings are one way of reducing the transmission of the virus. Again, note, I'm calling them face coverings just to distinguish them from face masks, which are typically used to talk about respirators, which are a different standard. So the CDC and OSHA both recommend using cloth face coverings in workplace settings, particularly where people are gathering and can't maintain 6 feet of distance between each other. Notice that I said recommend. OSHA has not issued regulations specifically about COVID-19. There are no OSHA-specific standards about the novel coronavirus, and there is no across-the-board requirement that workers must wear face coverings. Instead, companies generally need to consider their obligation under the General Duty Clause to address reasonably foreseeable hazards. So to summarize, face masks that are PPE are covered by OSHA standards, and employers must ensure workers wear them in compliance with those standards. Cloth face coverings are useful because they can help reduce the spread of the coronavirus, but they're not PPE and they're not covered by an OSHA standard. So if face masks that are PPE are required and cloth face coverings that are not PPE are not required, the question is, can employers require them nevertheless? And the answer is yes. Employers can require those too. If an employer has determined that the risk is reasonably foreseeable, that you could transmit the novel coronavirus in that workplace, and the use of a face mask, face covering, could help reduce the risk, then they can be required. Keep in mind, the requirement should make sense. If one person's going to an office and nobody else is going to enter, then a company might reasonably conclude that there's no hazard of transmission and not require that one worker to wear cloth face coverings at all times inside. So if employers can require them, the next question is, are there situations in which the employer must require them? And the answer is yes. Some states have strict face covering requirements. So even though OSHA nationally is not requiring their use, the state may do so. For example, in Pennsylvania, where I am, cloth face coverings must be worn at work all the time, with some exceptions, such as when one person is working alone in an office behind a closed door, or when it's not safe to use a cloth face covering based on the type of work being done. What can be confusing is that these rules might change across borders. Where Pennsylvania has a relatively strict rule, another state might have a looser one, and employees might protest about having to wear them in one jurisdiction when they don't have to in another. And just as an example, I looked this up this morning, the state of North Carolina encourages face mask use, but one of the counties, Durham County, actually requires them. And so you can have jurisdiction-specific requirements that are not just by the state, but by the local area. A company that has multiple offices, some of which are in areas where the authorities require them, some of which are in areas where they're not required, will have to decide what to do, whether you have one general policy for everybody or whether they can vary based on where you are. So the answer to the question, can employers require face masks, is yes, but whether they should do so and whether they must do so depends on the setting and the jurisdiction. So now that I've given that very well caveated answer, I'll turn it back over to Brian to discuss some of the employment issues that arise related to face coverings.
Thank you, Julie. As Julie mentioned, the employers in the U.S. can require their employees to wear face masks. Like with everything, there are certain limitations, however, on that. And those primarily relate to issues with disabilities and religious reasons for not wearing a face mask. As one can imagine, an employee may have a breathing disorder or some other disorder that prevents or makes it harmful or difficult to wear a face mask. Similarly, an employee religion may require that they wear religious garb that interferes at least, or it makes it difficult to wear a face mask. In both of those situations, employers need to be attuned to how to handle them and how to address those concerns from employees. And the best guidance is to engage with the employee in the interactive process, which is required under the Federal Americans with Disabilities Act. Engage in an interactive process, an interactive dialogue with the employee to find out exactly what the situation is, what is the medical condition or the limitations that prevent the employee from wearing the mask. And then work with the employee to come up with some other reasonable accommodation that accomplishes the same goal as wearing the mask. And that could be anything from not having to wear it when the employee is in an enclosed office as opposed to a cubicle, or even up to allowing that employee to work remotely due to the medical condition. That's the hallmark of addressing these concerns, this interactive dialogue and flexibility, if nothing else, with keeping an open mind to accommodations that the employee may need. Some things remain to be seen with this mask requirement and the accommodation issue. For example, given the severity and the harmful nature of COVID-19, it'll be interesting to see if employers conduct a cost-benefit analysis in addressing these requests for accommodation and determine that I'm willing to take the risk of the employee perhaps filing an ADA lawsuit as opposed to them not wearing the mask and potentially exposing the rest of my workforce. Along the same lines, it's certainly possible that other employees may feel that the workplace is unsafe if the employee requesting the accommodation is not required to wear a mask. It remains to be seen how these issues will play out, but there are certainly things that will for sure pop up down the line. The other issue with asking an employee to wear a mask in the workplace is if the employer is not going to provide the mask to employees, and the employee then needs to go out on their own and purchase a mask, whether and should an employer reimburse the employee for the cost of purchasing that mask. Our recommendation is if an employer is certainly going to have a mandatory requirement that employees wear masks, preference would be that the employer provide them. If the employer is not going to provide them, then given the relatively low cost of masks and the mandatory nature of the employer's policy, our strong guidance would be that employers either bear the cost of purchasing the mask either directly or certainly reimburse the employee for the cost of the mask. If there are no accommodations issues and an employer has a mask requirement and an employee refuses to comply, that for sure is a basis for disciplining the employee. And this is something that should be communicated as part of the policy that an employee wear a mask. In addition to reinforcing that employees should do that, they should also be reminded that if they don't, then they will be subject to disciplinary action, if appropriate. In fact, given the nature of COVID-19, employers and employers' duty to provide a safe workplace, employers will actually probably be obligated to discipline employees who are not wearing the face mask because it exposes others to potentially contracting COVID-19. At this point, I'm going to hand it back over to Julie to talk about screening of your employees, i.e. taking temperature, conducting COVID-19 testing. Take it away, Julie.
Okay, thanks, Brian. Temperature and symptom screening can certainly be one component of an overall strategy. As I noted earlier, employers have a general duty to provide a safe and healthy workplace, and one way of doing that is by preventing people with the virus from coming to work and transmitting it. I'll start, though, by pointing out there's evidence that people spread the virus when they are pre-symptomatic, before they start having symptoms, as well as when they are asymptomatic, because some people just don't seem to have any noticeable symptoms at all. So symptom and temperature screening don't help when people don't have symptoms. So in any return to work plan, it's important not to overemphasize the significance of screening. Neither OSHA nor the CDC has issued guidance stating that all employers must screen all employees at all times. The CDC in its guidance for businesses stated, screening employees is an optional strategy that employers may use. As for how often to conduct that screening, the CDC issued a restart readiness checklist, which stated, plan for conducting daily in-person or virtual health checks, e.g. symptom and or temperature screening, before employees enter the facility. So the general message is that daily screening is encouraged. Note that in some jurisdictions where screening is recommended, it doesn't necessarily have to be done at the work site. Instead, employees might be permitted to take their own temperature at home and report to work only if they don't have a fever. However, screening is effectively required in some contexts. Factors for determining whether screening is required include the type of workplace and whether there have been any probable or confirmed cases of COVID-19 in that workplace. For example, the CDC issued guidance about screening for critical infrastructure workers who have had an exposure to a known case but remain asymptomatic. Typically, people who have clearly been exposed are encouraged to stay home to spread the virus if they've caught it but aren't symptomatic. But for this category of workers, the CDC says that employers should measure the employee's temperature and assess symptoms prior to them starting work. In some states, screening is required in certain instances, so I keep emphasizing the importance of noting jurisdictional rules, but it really does matter. In Pennsylvania, as an example, screening is not generally required, except when there has been a probable or confirmed case in the workplace, then it does become required. Screening brings up a host of employment considerations, so I'll turn it back over to Brian to discuss some of those other issues.
Thanks, Julie. As Julie mentioned, screening is permitted by employers in the U.S. In particular, a common question among U.S. employers has been, can I take employee's temperature before they return to the workplace, and can I go a step further and test them for COVID-19? As I mentioned at the beginning of this webinar, the federal guidance has been somewhat general. However, on this issue, the EEOC roughly 2 months ago came out and clarified that even though temperature taking and COVID-19 testing is a medical examination, it is permitted because it's job-related and based on a business necessity, and especially in light of what is the direct threat posed by COVID-19. So it has been made clear to U.S. employers that they can do that sort of screening in addition to asking employees if they are exhibiting symptoms of COVID-19 or have been exposed to somebody who's contracted COVID-19. All of these tests, the temperature screening, the COVID-19 testing, the EEOC has told employers that it must be accurate and reliable. And our guidance is that if you're going to administer or if you want your employees tested for COVID-19, employers are recommended to administer that test either on their own or through a medical provider and not require employees go get tested on their own. With all of this screening and the fact that temperature screening and COVID-19 testing is deemed a medical examination, there are certain privacy issues that employers need to be aware of when they're doing this sort of screening. Under the Americans with Disabilities Act, any data resulting from this screening is considered medical information and must be stored separately from the employee's personnel files, and of course must be maintained confidentially. Additionally, if an employer is either a covered entity or a business associate, those are defined terms under HIPAA, then there may be additional obligations that an employer has with regard to storing this information. And then drilling down even further, if the temperature screening is being done through a biometric device, for example, certain states in the U.S. have biometric laws regarding the maintenance and storing of that sort of data. And so employers need to be aware, if they're operating one of those states, of their obligations with respect to that data. Certain employers may consider whether I can ask an employee to self-certify before they come to work that they don't have a high temperature or not exhibiting symptoms of COVID-19. There are pros and cons with that. Certainly it eases the burden on employers and places the responsibility on the employee, but ultimately it's not necessarily the most reliable method. Additionally, if employees are being asked to conduct some sort of home screening or temperature check, it does raise issues with whether the employer is required to reimburse the employee for the equipment, the thermometer, what have you, for that screening. Additional issues to consider that I'll just briefly touch on is what entitlement does an employee have to be compensated for either the time it takes for the screening, for the temperature check or the COVID-19 test, or the time spent waiting to have that screening and test done. Those are open questions that obviously have not been litigated yet or answered by any governmental authority. As for the time spent on the temperature screening and the testing, the key question is whether that time or that activity is an integral and indispensable part of the employee's principal activity. And this is drawn from cases where the issue has been whether an employee is entitled to be compensated for having to put on PPE and do other necessary tasks before starting work. The consensus seems to be at this point that, at least erring on the side of caution, that employees, especially non-exempt employees, should be compensated for the time spent during the screening and testing. The issue with whether they should be compensated for the time waiting to be tested or screened, it is our view that that's more than likely not going to be something they need to be compensated for. So at this point, I want to transition to talking about the importance of monitoring and updating their policies in light of the reopening. So the COVID-19 pandemic has required employers to tackle a host of issues that they hadn't had to encounter before. And with the reopening, it's important that employers make sure that their policies are, number one, updated to reflect the changes in place, but number two, are communicated clearly and in a widespread manner to their employees. So, for example, with the passage of the Families First Coronavirus Act back in April, that impacted and created new obligations for paid sick leave and paid FMLA law. Employers, and that law, that act is going to be in effect until the end of this year. Employers should consider and put together a policy similar to an FMLA policy that addresses that paid leave obligation. Remote and teleworking is the new flavor of the day. Employers who did not have teleworking policies prior to COVID-19 should certainly put one in place now, especially if a large amount of their workforce is engaging in that sort of work. And of particular importance for that policy is regarding timekeeping for teleworking employees, especially non-exempt employees who need to track their time and be paid overtime if appropriate. It's important that employers update their policies on that issue so that employees are reminded that even though they're teleworking, they are still required to record their time in an appropriate manner or certify that their time is accurate. For example, they should be reminded that even though they're teleworking, they're not to engage in any unauthorized overtime and things of that nature. Social distancing is also going to be a permanent fixture of the workplace, or at least for the foreseeable future. Policy should be prepared on that topic. Just keeping distance from yourself, wearing a mask, for example, social interactions, no more handshakes and backslaps, things of that nature. There should be policies either updated or drafted that address what will happen when an employee does test positive for COVID-19, or at least there is a suspicion of that. Along with all of these policies, I mentioned that it's important to clearly communicate them to employees. They should be drafted in basic layman's terms. They should be emailed or rolled out in an addendum to any existing employee handbook. And like most employers do, there should be a written acknowledgement from the employee of their receipt. I see that we're running short on time, so I'm going to wrap up with Julie and I talking about predictions for the future, what we see coming down the pipe. So I'm going to hand that off to Julie to give her thoughts.
Sure. I'm not going to make any predictions about the spread of the virus. The news this morning was not good about surges in some states here. But as if that's not enough, I want to encourage you to think about what I call the double crisis. And by this, I mean some other crisis that hits, like a hurricane or wildfires or tornado. And that might happen while the pandemic is still with us. You may need to think about how to adapt your plans and policies for a double crisis. This could include supply planning. For example, if you have a tornado shelter, should you ask to add face coverings to your supplies? The effects of another crisis could be magnified because of the pandemic. For example, if people are evacuating to crowded shelters, the virus could surge, or if wildfires cause respiratory distress, the impact of the virus might be worse. Consider how your policies and programs might need to be adapted so that you're ready for a double crisis situation. On that cheery note, I'll turn it back over to Brian.
Thank you, Julie. So the biggest prediction that I see in all of this is, and perhaps this is just a consequence of doing business in the U.S., is there's going to be certainly an increase in litigation related to COVID-19 employment issues. In fact, we're already seeing it. In addition to the expected and traditional increase in areas of disability discrimination and age discrimination, and now suits related to the new Families First Coronavirus Act and the paid leave laws, we're seeing novel claims start to sprout up in the employment context. One of those is what's called a public nuisance. That is a doctrine that's hundreds of years old, but is now being applied in the employment context, where employees are now saying, the workplace I'm being asked to come back to is not safe, and it actually contributes to the public spread of COVID-19, and therefore I, as an employee, am entitled to relief, or at least not required to come back to work based on that. There's been a high-profile case filed against McDonald's based on this theory, and so I suspect we'll see more of them pop up as the weeks and months go by.
Well, Brian and Julie, thank you so much for joining us and giving us a bit more insight on what's happening in the U.S. Oftentimes, the U.S. is slightly ahead of us in terms of development in the legal landscape, and so there could be some of the issues that you're talking about in terms of what you see next. That could potentially be something that Canadian employers are going to have to grapple with as we go forward. I would encourage everyone on the call, if you do have any questions, whether it be for your U.S. subsidiary, affiliate, by all means, you can reach out to either the lawyer that you regularly work with in Canada or directly to Brian and Julie. We certainly want to make sure that you're covered no matter where your workplace is. So that takes us on to our regular Canada Q&A. And today we have Taylor Buckley, a senior associate in Vancouver, and Stephanie Lewis, who is counsel in our Ottawa office. If you've been tuning in, you'll recognize Taylor and Stephanie's voices. So with that, there's a number of questions that we've collected. But Stephanie, I'm going to start with you. And for those of you who are tuning in Ontario, you'll know that earlier this week, the government announced that daycares could reopen. And so with that development, Stephanie, does that mean that it's possible for employers to require employees who have been off work due to child care obligations, now that those daycares are open or in the process of opening, can employers now require those employees to return to work?
Well, when those parents are done celebrating, there's certainly some things to consider here. So up until today, it hasn't been possible to force employees to return to work if they have child care issues related to COVID-19. That's because the Employment Standards Act Amendment Act, which was passed on March 19th, provided job protective leave to employees who, among other things, needed to provide care to a designated family member for a reason related to COVID-19, school, or daycare closures. In addition to job protective leave, parents in this situation would also have had possible claims for discrimination due to family status if they've been forced back to work, so it was a very sticky situation. That said, as of today, when daycares reopen across Ontario, the ESA Amendment Act will no longer provide protective leave to parents of children who attend daycare and who can return to daycare, and those two pieces are quite important. Due to this week's government announcement, this will not apply if children who need care and are school age do not have school to go to, or if the daycare that your employees' children attend is not opening in the near future. For parents whose children attend a specific daycare that is not yet set to reopen, and there are no other daycare alternatives available for their kids, they will still have the benefit of a job protective leave. That being said, if employees at issue are able to send their children to daycare starting on Friday or next week, then employers should be able to insist that they do return to work. If the employees state that their children are unable to go to daycare, that you don't have to leave it at that. You are entitled to ask for a note from the daycare operator indicating why. So is the daycare remaining closed for the time being? Is the daycare operating at 50% capacity and the employee's kids are not among those being welcomed back? If the employee refuses to provide a note or indicates they simply don't feel comfortable sending their kids back to daycare, it's going to be up to the employers to decide how to deal with those employees. And I caution here. So while disciplinary measures up to and including termination are amongst employer options, in light of everything that has been happening, the better alternative would probably be to provide unpaid leave and to advise the employees that there is no guarantee of their job remaining open to them when they're ready to return. And finally, a little nuance, if there's an immediate family member in the employee's household, whether it be the child who could otherwise go back to daycare or another family member who is immunocompromised, care should be taken before terminating that employee, as it could potentially lead to a claim of discrimination. If that argument is raised, we recommend two things. First, seeking a medical note confirming the immunocompromised situation, and two, call us or someone. Seek further legal advice. There's also an issue, and I will say this number once, but when you hear this number, you're going to say this is the reason that these lawyers have telephone numbers. Section 50.1, sub 1.1, sub B, sub 3 of the Employment Standards Act may also provide protections to those in a high-risk category. Again, I read it for the people who actually would retain that. I know that I would not. Please call us if you want more information on that.
Thanks, Stephanie. Taylor, over to you and a few questions about the wage subsidy. And one question that we received is employers are curious to know whether there's restrictions on what can be done with the wage subsidy funds that are advanced by the government.
Well, the wage subsidy funds need to be used for actually paying wages. So it gets paid to the employer, but it can't just be, taken into general revenues and things like that. It has to be, the employers have to be able to show that has flowed through to the employees who are being compensated as part of the top-up and not being squirreled away for any other purpose. So it does need to be tracked.
Thanks, Taylor. Stephanie, Ontario's had a lot of legal developments over the last couple of weeks, especially. We just touched on the fact that daycares are reopening and the various accommodations that are under the Employment Standards Act. The big news a few weeks ago was the Ontario regulation that dropped and converted temporary layoffs that occurred after March 1st to leaves of absences that were protected by the Employment Standards Act. One question that we've got now is it still possible for employees to claim constructive dismissal?
Thanks, Andy. So for those of you who joined us last week, you're probably thinking, didn't the brilliant and capable Megan Russell provide a presentation on this a week ago? And you would be right. So for a detailed analysis, I commend you to Megan's presentation, which is available on our website, along with a recording of all of our COVID-19 employment webinars. The high-level answer to this question is yes. Employees will be able to claim constructive dismissal in certain circumstances. I'll briefly address those situations under both the Employment Standards Act and at common law. So the regulations remove the ability under the Employment Standards Act to claim constructive dismissal relating to a specific time frame and specific circumstances. So firstly, the reduction in wages or hours has to have happened between March 1st and before 6 weeks after the state of emergency ends in Ontario. So if we're talking about a time outside of that period, if an employee had a wage or hour reduction before March 1st or has one after that 6-week period ends, it's not exempt from a constructive dismissal claim. Secondly, the reduction in wages or hours needs to be COVID-19 related. And as such, if it wasn't for that reason, if it isn't tied to COVID-19, then the person can bring a constructive dismissal claim. And thirdly, it needs to be temporary. So if the reduction in wages or hours was as a result of something permanent, it would still be subject to the ability to make a constructive dismissal claim. So in short, if the reduction in wages or hours doesn't meet these criteria, then employees could still bring constructive dismissal claims under the ESA. Also, if an employee was subject to a temporary reduction in hours or wages and resigned their employment prior to May 29th, 2020, which is the day of the regulation, they are not precluded by the regulation from claiming constructive dismissal under the ESA. as for common law constructive dismissal, the regulations apply to the Employment Standards Act. So based on a straight reading of the regulation, it doesn't preclude common law claims. However, as pointed out by Megan last week, this will ultimately be a legal question, and we'll see how the analysis plays out once these claims are being adjudicated by the courts in a year or two.
Thanks, Stephanie. And I see that there's a question about the regulation, and it comes from Tamara Lord asking, it's, in some cases it's going to be hard to assess if a temporary layoff was purely due to COVID-19 or workload or otherwise. Do we default then to the new leave or not? And that's a really good question, Tamara. We've tried to address it in one of the bulletins that we sent out at the end of May, and ultimately we think that there are going to be some arguments that a particular layoff or pay cut or hours was not for reasons related to COVID-19. One thing that the regulation does not seem to indicate is that it's solely related to COVID-19, and so I think you're probably right to consider the fact that this is likely going to be now a deemed leave of absence rather than a temporary layoff. The time frame is going to be so important because, generally speaking, most wage cuts and layoffs that were taken within the COVID-19 period that Stephanie just discussed that are likely going to have been in response to the COVID-19 pandemic. So you're probably on good ground to say that this is now a deemed leave of absence. All that said, if you're going to get a challenge on it or you're anticipating it, make sure that you have a very good and strong litigation file ready that shows what the downturn in the business is, maybe what the reduction in the workloads were, and how you attribute that to COVID-19. Taylor, back over to you, and again, another question on wage subsidy. We've had a few employers, they're I think, questioning how the whole thresholds work and whether or not the wage subsidy prevents them from paying their employees their full wages under the wage subsidy program.
Whether it prevents them from paying their full wages? No.
Yes.
Yeah, so the answer is no. I think the intent and employees are, in fact, explicitly encouraged by the government to provide the top-up, the 25% top-up as the wage subsidy, as part of the wage subsidy. So absolutely nothing that's being implemented is preventing employers from paying their employees more other than the limits in terms of eligibility for the emergency response benefit.
Great, thanks, Taylor. And now, Stephanie, back to you. And again, another question about this regulation, and recognizing that obviously we've done the presentation last week, and we've made some bulletins, but this still remains, I think, a really difficult thing for employers to grapple with because it is such a fundamental change in how the Employment Standards Act ordinarily operates. Is there standard language that you recommend that employers use to notify their employees that their temporary layoff has been converted to an infectious disease leave of absence under the Employment Standards Act?
So something that Andy and all of the members of our Ontario employment team know is that there certainly is. I've been encouraging my clients to reach out to their employees with letters explaining the transition to the leave, so that in part to make sure that there is a clear understanding of where things stand, and in part to set up my clients for success, our clients for success in terms of meeting the criteria for the transition to leave under the Employment Standards Act. A further advantage of sending these updates is that they encourage clear communication, just like Brian was talking about earlier when he was talking about engaging in the interactive dialogue with employees. So we want to make it clear that the reduction in wages or hours meets the criteria that they were temporary, that they occurred after March 1st, 2020, and that they were due to COVID-19. So in these letters, the employees are first reminded that they were initially temporarily laid off due to COVID-19 on a date following March 1st, 2020. So you're setting out 1, COVID-19, 2, temporarily laid off, 3, within the time period. Then I insert a language introducing the new regulations that were enacted on May 29th, and I explain the transition to the employee status. So that looks something like this. The new regulation converted COVID-19 related temporary layoffs to leaves of absence without pay. As a result, the employee is now considered to be on infectious disease leave rather than on a temporary layoff. While the regulations allow for this leave to continue until 6 weeks after Ontario's state of emergency ends, the employee will be contacted about their recall date as soon as it is known. So all of that I tend to load into the very first paragraph. As well, there are continuing obligations to those employees. And so what I recommend doing next is addressing how benefits and or stock options will be treated during the leave of absence. And then generally I recommend concluding the letter by letting employees know that the employer is going to continue to be in touch with any updates and giving a contact person for if the employee has any questions. So that's generally how I have been recommending that people handle it, just for the sake of clarity and to reduce any misunderstandings at a later date. And if anyone has any questions about that, please feel free to call me, because talking about it is one of my favorite things.
Thanks, Stephanie, and it certainly is one of the group's favorite things, because, as I say, it's evolving quite rapidly, and it's really requiring a lot of analysis to ensure that we are able to provide what we think is going to be the best practical outcome as people try to deal with this. Taylor, back to you, and again, another question on the wage subsidy. And we've talked about whether or not employers can still pay their full wages to employees under the wage subsidy. What about if you're in receipt, if you're an employer and you're in receipt of the wage subsidy, can you increase wages for your employees? Oh, Taylor, you might be on mute.
Sorry, the wage subsidy is based on kind of the I'm not going to call it a leave, but the pre-pandemic pay, and it's not going to be able to be used to kind of increase as a percentage beyond what the employee had been earning. It's not to be used for wage increases for employees. And just to go back in terms of restrictions as well, and it's a question in a Q&A about use for severance, and severance is not eligible remuneration for the wage subsidy as well. It's something to flag since I've seen it come up today in the chat. So that's excluded from the usual earnings that are eligible for the subsidy.
Great, thanks Taylor, and Stephanie, I'm wondering if, as a final question on this regulation, you can maybe just give some information about what obligations employers have to employees who are on a leave of absence, given that there now may be an entire class of employees who were previously on a layoff and now find themselves on a statutory leave of absence. And Stephanie, maybe you might want to check if you're on mute.
Oh, and I was on mute. That was me failing a test 14 weeks in. So one of the great things about this question in today's webinar generally is it's given me a number of opportunities to give a shout outs to the fierce women that we work with. So this topic was addressed last week in more detail by Larissa Workowicz, our smart and capable team member out of Toronto. And so I'd like to thank her right now for preparing the materials that I am cribbing in this overview answer. The obligations are largely the same as those set out under the Employment Standards Act for employees on statutory leave, with some exceptions. So firstly, the employees are entitled to continued participation in benefits plans. These plans include pension plans, life insurance plans, extended health, dental, accidental death, and dismemberment plans, and there are a few exceptions. So the exceptions to this entitlement are, firstly, if an employee elects in writing not to participate. So if somebody has given you a written statement that they don't want to continue to participate in their benefits, then they're not covered by this. And secondly, the regulations allow that if an employee was taken off benefits prior to the regulations being enacted on May 29th, 2020, the employees do not need to be put back on benefits. So those are the exceptions to continuing benefits. Secondly, employees are entitled to continued employer contributions to benefit plans. And thirdly, employees are entitled to reinstatement to their position, so either the position they most recently held, if it exists, or to a comparable position if it does not. So again, these are the criteria that are set out in terms of statutory protective leaves under the Act. If anyone has any questions about those, please feel free to reach out to a friendly member of your local Denton's team.
Thanks, Stephanie. And one final question that we'll take, I saw from Patricia Stewart asking, when do we have to end salary reductions? When is the end date? Well, that is going to be a decision that will ultimately be driven by your business. What we can say is that the regulation that we've been answering a lot of questions about today and over the last few days in Ontario in terms of the protection that that law gives to employers who have either put employees on a temporary layoff or reduced their wages, that protection is going to cover what they call the COVID-19 period, and that's going to be the state of emergency in Ontario plus 6 weeks after the state of emergency is terminated. So to put that in real terms, right now the state of emergency in Ontario has been extended to the end of June, and so that extra 6-week period would mean that you have protection against a constructive dismissal up till the middle of August. Now, we don't know if the state of emergency will be extended. One would likely assume that it will, and that would then again push out that statutory protection. But once that statutory protection is lifted, it doesn't mean that your wage cuts have to be ended. Again, that's going to be a business decision, and you'll have to consider your risk from a litigation standpoint and determine whether or not the business can return to normal or whether or not there's still some flexibility needed in your cash flow. So hopefully that answers. We're gonna cut things off there today. I want to thank all of the speakers. The only other thing I might ask is if Brian is still on the line, and I think he is. We did receive, Brian, a question about U.S. layoffs in the lead up to the presentation, and just asking how long a furlough can last in the U.S. Brian, do you have maybe 2 minutes that you could address that question?
Sure. So there is no black and white answer to that. First of all, there's no federal law that dictates specifically when a furlough is now deemed a permanent layoff or a termination. It's a state-specific issue, if it's addressed at all by any state authority or cases. So what I would say is there is one law that suggests that anything beyond 6 months would be deemed to be permanent or termination at that point. And that's the Federal WARN Act, which governs basically if you're going to have a mass layoff of employees, they need to be provided 60 days notice of it and be paid benefits and paid during that time. The law does not address specifically when something is generally deemed to be a termination or permanent layoff, but the regulations and the language of the statute says that an employment loss under the WARN Act occurs only when it's a non-temporary layoff. And a temporary layoff is defined or viewed as something 6 months or shorter under the WARN Act. So again, it doesn't apply generally to any sort of furlough, but I think a good and guidance would be anything beyond 6 months is going to be viewed as either constructive termination or a permanent layoff.
Great, thanks, Brian, and I think that covers it for today. So thank you to our speakers. Thank you most of all to all of you who have tuned in and also have tuned in over the last 14 weeks. And that leads to a brief programming note for next week. We're heading into the summer months. The weather is getting better and better, and so we're going to be taking a pause on our webinar series. So next Friday's webinar will be our last weekly COVID-19 webinar. Now rest assured, we are going to continue to keep you updated of any developments over the summer through bulletins, and we may also have the odd webinar, but they will not be on a weekly basis. So what are we going to plan for next week? We think we have a great way to have the finale for this portion of our program. We've assembled a roundtable of some of Canada's HR leaders, and they're going to share their views on how their businesses have dealt with the unprecedented challenges posed by COVID-19, and also we'll talk with them about return to work plans. So look for that email invitation early next week. Of course, we'll be happy to have you join us. And thank you again for listening in today and for all of the other weeks. And most importantly, have a great weekend and stay healthy. Thanks, everyone. Bye-bye.